and welcome to Know Your Laws by Law Offices of 𝐮𝐻𝐸 Advocates and Associate. This is your host 𝐮𝐻𝐸𝐤𝐥𝐥𝐸 bringing you to the latest update on legal matters. Start in an important update. The Punjab and Haryana High Court has observed that living together with another woman without dissolving the marriage from the earlier spouse may amount of offence of bigamy. These observations came in response to a writ petition filed by a living couple seeking police protection from the alleged threat by the relatives of the woman. They have been living in a live-in relationship since September this year, and their relationship has been accepted by the man's family but not by the relatives of the woman. The police stated that they were getting death threats from the woman's family and hence needed the police protection while examining the plea. The court noted that the man was already married, having a girl child with his wife, and a petition for divorce from her was still pending before the family court. After considering the petition, the Justice Kuldeep Tiwari concluded that only bold and vague allegations regarding the threats had been made without placing any supportive material. On record to corroborate their allegation, Justice Tiwari also highlighted that the hidden intention of petitioner behind filing this petition was to avoid any criminal prosecution. In case of adultery, accordingly, the court dismissed the petition. In the next update, a plea has been moved before the Kerala High Court challenging the recent amendment introduced by the central government in the surrogacy regulation rules of 2022. As per the new amendment, intending couples who want to undergo surrogacy can only use their own gametes and not donor gametes. Before the amendment, the rule permitted the usage of donor or kites for surrogacy. The writ petition was moved by the middle-aged couple who are unable to conceive naturally as their petitioner wife was suffering from various illnesses. She was medically advised not to plan a pregnancy or undergo any fertility treatments. The petitioner thereafter opted for surrogacy, but she was informed that due to organ failure, she was unlikely to produce oocytes or from her own ovaries. For undergo surrogacy, the petitioner requires donor oocytes from another donor lady for undergoing surrogacy. However, due to the recent amendments, she is unable to do thus. The plea challenges the constitutional validity of the new amendment as violate of fundamental rights and ultra-vires to the existing regulation. It also seeks direction from the court to permit the petitioners to undergo surrogacy using donor oocytes. During hearing today, Justice Dean Ramachandra sought response from the central and state governments. To know the purpose behind the amendment, the court amended the matter and noted that it was a serious and important issue. Now, in another update, the Supreme Court has held that a judicial magistrate cannot entertain a protest petition against for taking cognizance of a final report. In this case, a chief judicial magistrate took cognizance against an accused for the offence of murder based on final reports filed by the CID. The victim's father filed a protest petition taking objection that magistrate did not take cognizance against other accused after another order was passed by the chief judicial magistrate in cognizance against the other accused persons. Then the other accused person against whom cognizance was taken subsequently filed a petition before High Court against the action of magistrate. Since the High Court rejected their petition, they appealed Supreme Court bench comprising Justice 𝐮𝐸𝐸 S. and Pankaj Mittal expressed surprise at the magistrate entertaining a protest petition against an order taking cognizance. The bench stated that magistrate has no power to modify an earlier order taking cognizance. Thus, subsequent order passed by the CGM taking cognizance against the applicants was set aside. And lastly, the Punjab and Haryana High Court has granted bail to a man booked under Unlawful Activities Prevention Act, that is UAPA. The court observed that there was no prima facie made out in the case of allegedly planning to commit some terrorist acts based on relations with Pakistan. The court was deciding the bail plea of 𝐮𝐸𝐸𝐸, against whom an FIR was launched in 2020 under IPC, UAP and Arms Act. It was alleged that he was a part of gang who was hatching plans to commit some terrorist acts in different places in the country. As per disclosure statement of the co-accused, they had robbed 30 kg of gold from IIFL Gold Loans branch Ludhiana A division bench of acting Chief Justice Ritu Bhari and Justice Manisha Batra noted that no specific role had been attributed to Singh to support the allegations of being involved in anti-national activities, that he had been in custody for about 3.5 years, and so far only out of 38 witnesses has been examined. No recovery had been effected from him. In this case, the court concluded that on the basis of allegation, prima facie, no case could be stated to have been made out to presume that there had been a conspiracy to form membership of a terrorist gang. The court also said that the statute of UAP has strengthened the provisions, but that makes the duty of the court to be onerous, and it was settled that merely because allegations were serious on the reason bail cannot be denied.